finals of the 2013 Hardt Cup. In a moment, you'll be hearing from my esteemed colleagues about the problem itself, the competitors, the judges, but first I wanted to take a brief moment to thank them. More than anyone else, the four people standing to my right are responsible for this tournament and for this final round tonight. Now, I won't go on to thank all the people who are deserving of thanks. I think you can find that on the first page of the program tonight. But I did want to say just one quick thank you to Dean Levy for his support of the Moot Court program. The support coming from his office really sets the tone throughout the law school, which has been invaluable throughout the year. Now, momentarily, I will turn it over to Corey Blyleven, our intramural chair, to talk about the tournament itself. But in that moment, if you all could please turn off your cell phones and any other electronic devices that may go off during this round, laptops included, so on and so forth. But without further ado, thank you very much for coming. Welcome, and our intramural chair, Corey Blyleven.
The Hardt Cup is the annual first-year moot court competition. The cup is named in honor of A. Lee Hardt, a student who passed away after his first year in 1962. The Hardt Cup is conducted over 3 weeks. The first week is mandatory, and the problem is based on the LARW appellate brief. The second and third weeks are elective. The second week, anyone who wants to participate can, and in the third week, the top 40% of the 1L class is invited to participate. After that, the top 10% of the class is invited to join the Moot Court Board, and 8 competitors are selected to be quarterfinalists for the Hardt Cup. They are judged by a panel of faculty and alumni who select our finalists for tonight. The finalists tonight will argue for 15 minutes each, and then the judges will decide who the winner will be. It is within the sole discretion of the judges to decide the winner. They don't have any set criteria. Doug Hollins will next introduce the problem for tonight.
Carol Ann Bond discovered that her best friend, Merlinda Haynes, was pregnant with the child of Bond's husband, with whom Haynes had been having an affair. Bond decided to exact revenge, borrowing chemicals from her workplace, as well as ordering some via the internet, and spreading them on Haynes's home doorknob, car door handles, and mailbox on 24 separate occasions. Haynes reported the incident to the police, who surmised that the substance was cocaine and suggested Haynes wash the surfaces. She next reported the substance to the U.S. Postal Service, who, after an investigation, arrested Bond and charged her with 2 counts of violating 18 U.S. Code Section 229, a provision that is part of the implementing legislation for the Chemical Weapons Convention. Bond pled guilty and appealed the constitutionality of the statute, as applied to her situation, to the Third Circuit Court of Appeals, claiming that it fails to satisfy the 10th Amendment. After the Supreme Court of the United States held that Bond has standing to bring the challenge, the Third Circuit held that the statute is constitutional under the court's current jurisprudence. The Supreme Court granted cert to determine the constitutionality of the act. And now Zishang Shen, another Hardt Cup coordinator, will introduce this year's judges.
We have a distinguished panel of judges joining us tonight. Judge John Tinder has served on the United States Court of Appeals for the 7th Circuit since 2007. Prior to his appointment, he served as a district court judge for the Southern District of Indiana. In addition to spending time in private practice, Judge Tinder has a dedicated record of public service. He has served as the United States Attorney for the Southern District of Indiana and has also served as a public defender and the Chief Trial Deputy for the Marion County Prosecutor's Office. He graduated from the Indiana University School of Law. Chief Judge Robert Conrad has served on the United States District Court for the Western District of North Carolina since 2005 and has served as the Chief Judge since 2006. Prior to his appointment, he served in the office of the United States Attorney for the Western District of North Carolina, including 5 years as the United States Attorney. Chief Judge Conrad received his JD from the University of Virginia. Judge Kimberly Mueller has served on the United States District Court for the Eastern District of California since 2010. Prior to her appointment, she served as a federal magistrate judge. She has also served a 5-year term on the Sacramento City Council. Judge Mueller graduated from Stanford Law School. While in law school, Judge Mueller also served as a judicial extern on the United States District Court for the Eastern District of California to Judge David Levy, who is now the Dean of Duke Law. And Jules Mugema will introduce this year's competitors.
So from New York City and representing the petitioner tonight, Jurna Shah is a 2010 graduate of Yale University, where she majored in political science and international studies. Here at Duke, she's actively involved in the Women Law Students Association and the Public Interest Law Foundation. This summer, Jurna will be working as an intern with the legal department at the United Nations Food and Agricultural Organization. From Tallahassee, Florida, and representing the respondent tonight, Kathleen Wade graduated from Furman University in 2012 with degrees in economics and Asian studies. Here at Duke, she works with the Volunteer Income Tax Assistance Organization and the Street Law Middle School Mock Trial Team. This summer, Kathleen will be working in the Houston office of Vincent & Elkins and at Duke's Asia America Institute for Transnational Law in Hong Kong.
Are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Good afternoon. And we will proceed in the argument of Bond versus the United States for the petitioner, Ms. Shah.
Mr. Chief Justice, and may it please the court. My name is Jurna Shah, counsel for the petitioner, Carol Ann Bond. With the court's permission, I'd like to reserve 1 minute for rebuttal.
Yes.
This case is about preventing Congress from using the treaty power as a backdoor to enact legislation that circumvents fundamental principles of federalism enshrined in our Constitution. This court should reverse the lower court and hold that the Chemical Weapons Convention Implementation Act is unconstitutional as applied to Ms. Bond's case for 2 main reasons. First, the Act exceeds Congress's authority under the Necessary and Proper Clause. And second, even if the requirements of the Necessary and Proper Clause were met, the Act violates principles of federalism embodied in the 10th Amendment.
Ms. Shaw, do you contest the validity of the treaty?
No, Your
So
Honor,
you
we do not.
concede the treaty is within the valid authority of the President to
That's correct,
enter
Your Honor.
with the consent of Congress?
Yes, Your Honor.
Having conceded that, how do you get around Holland?
Your Honor, we do not contest the holding in Holland. We do believe, however, that it should be limited. Holland was decided in 1920 when international treaties covered a limited range of subjects. Today, international treaties cover a wide array of different subjects. And the principle in Holland needs to be read to include a balancing of national and state interests when deciding what is necessary and proper for Congress to legislate when enacting treaty implementing legislation.
How do you read that line in Holland referencing invisible radiation from the general terms of the 10th Amendment? What did Justice Holmes mean?
In that case, Your Honor, Justice Holmes potentially referred to the fact that this court should look to the principles of federalism embodied within the 10th Amendment that serve as a limitation to Congress's authority under the Necessary and Proper Clause to enact treaty implementing legislation. This court held in the case of Reed v. Covert that treaty implementing legislation and treaties themselves should still comply with the Constitution. And to that extent, they should be faithful to the principles of federalism that are embodied within the Constitution.
What specific provision of the Constitution was violated by the statute in question here?
Your Honor, the Congress's implementing legislation is perhaps too broad to be necessary and proper to the implementation of the treaty itself. And secondly, the treaty, the act, is perhaps violates principles of federalism that are embodied within the 10th Amendment. The fact that there is no limitation to what Congress can do under the Necessary and Proper Clause is troubling because without that limit, Congress can enact any sort of legislation as long as there is an underlying valid treaty. And that is troubling, especially when we look at the case of Ms. Bond, which is a purely domestic, local, run-of-the-mill criminal case.
Well, wait a minute, though. If I understand the facts, and correct me if I'm wrong, one of the areas where she was spreading these chemicals was on the mailbox.
Yes, Your Honor.
And haven't we had a traditional long-standing protection for Postal Service and its facilities, including mailboxes, even though they're not owned by the post office, but they're utilized by them?
Yes, Your Honor.
So isn't there some federal interest there?
There may be a federal interest if a Postal Service employee was harmed in the process. However, in this case,
Well, that's why we protect those, because a Postal Service employee could have been harmed.
no, Your Honor, because this challenge is an as-applied challenge, the court should look only to the circumstances within this case itself. There was no federal employee that was hurt in the process. This was a local incident between two individuals with a personal conflict. Ms. Bond used a chemical that is readily available over the internet and was available in the common storage areas in her workplace. It took her 24 attempts, and the worst injury that resulted was a minor burn. This isn't anthrax or smallpox. It isn't the type of chemical that was envisioned by Congress when it enacted this legislation, and it wasn't the type of chemical that is envisioned by the treaty itself when it discusses the threat of chemical weapons.
Didn't this case end up in federal court because, in fact, the local police did not investigate or enforce? What are we to make of those facts?
Your Honor, the local police began to investigate the case. However, there's nothing in the record that indicates that they could not have competently exercised the prosecution of Ms. Bond under state law. Unfortunately, Ms. Haynes turned to the Postal Service and involved federal authorities early on in the case. However, there's nothing in the record that indicates that state authorities could not have carried out the same investigation and reached the same conclusion. The fact that federal authorities and federal law enforcement became involved suggests that perhaps the act is so broad that it envelops local conduct such as Ms. Bond's.
Well, it was the postal authorities, though, in particular, not the FBI or some other agency, because of the mail facility being involved.
That's true, Your Honor.
So that was their interest.
Ms. Haynes called the Postal Authority out of concern that perhaps there was something else that needed to be addressed. However, that still does not mean that state authorities could not have competently addressed the issue and prosecuted Ms. Bond.
Of course, that's true of many things. Bank robberies, for example, drug violations, lots of firearms violations, all have a component that would, or an aspect that would allow local authorities to handle those in some manner, but Congress is free to act on those matters.
Yes, Your Honor. Congress is free to act when the treaty implementing legislation is necessary and proper, meaning it's rationally related to some sort of constitutionally enumerated power, which is the treaty power in this case. What's happening in this situation is the implementing legislation is so broad that it covers an array of conduct that is so local in nature that this court should give deference to state authorities when there is no other federal interest present. And by federal interest, had the crime occurred in a special federal jurisdiction, had there been some sort of substantial act of terrorism or a national message involved, or if the victim, as Mr. Chief Justice you had suggested, if the victim had been some sort of federal employee or someone with a federally protected status, then perhaps federal intervention would be justified.
So it's the size of the result that matters here. If this had been Oklahoma City, you would be comfortable with the federal involvement here, but because the result wasn't as severe, it's not within the congressional authority?
Your Honor, the result and the size of the result may be one factor to be considered. The case of the Oklahoma City bombings certainly involves some sort of federal intervention. But what we have in this case, and because it is an as-applied challenge, we only need to look at the facts of this case in particular.
Well, besides the result, the magnitude of the result, what is the difference between this and Oklahoma City?
Well, Your Honor, the potential threat, Oklahoma City was a clear act of terrorism. It had far-reaching implications for the country. It posed a threat to national security, and it potentially had some international dimensions. In this case, we're talking about a dispute between two individuals, which has very little to do with national security and which could have been prosecuted under existing state law without overreaching to an international treaty on chemical weapons. Chemical weapons, or the treaty itself, was designed to address something of larger international concern. The preamble to the convention states that the goals of the treaty are disarmament and the elimination of weapons of mass destruction. This can hardly be considered in any common understanding to be a weapon of mass destruction.
Well, in the Oklahoma City case, it was fertilizer.
Yes, Your Honor.
And you would concede that was as used, was a weapon of mass destruction.
Yes, Your Honor. and the fertilizer would fall within the definition of a chemical weapon in the Act. However,
As would these chemicals.
yes, Your Honor, they do, and that is troubling because the definition is so broad that it includes a variety of uses and a variety of conflicts, many of which are not terrorist activities, and many of which were not designed to be addressed by the treaty implementing legislation, especially pursuant to an international treaty regarding the regulation of chemical weapons for peace and security.
If we adopt your position, is one implication that the executive could not make broad pronouncements?
No, Your Honor, absolutely not. This case is an as-applied challenge. If this court were to rule in favor of the petitioner, the implementing legislation would stand as it does currently, and the treaty itself would be an absolutely valid use of the presidential's treaty power. So there's nothing to say that the decision in this case has to reach as far back as a limitation on the treaty power itself. It simply means that the act is too broad and needs to be narrowed in some manner so that it doesn't cover local conduct such as Ms. Bond's, especially when that local conduct is really in the domain of the states, and that comes at a price of federalism to the extent that federal authorities are allowed to use a congressional act passed under the necessary and proper clause to prosecute local individuals in a very local situation.
So how would you narrow it? What language or what limitations would you place to narrow it?
The line that should not be crossed is when the federal government, without any reason or justification, is intervening in a traditional area of state enforcement. The presence of some sort of federal interest needs to be there before federal authorities can come in and enforce the act. And by federal interest elements, we can consider anything from the fact that it occurred within a federal jurisdiction, whether it was an substantial act of terrorism, whether it carried a national message, or whether the victim had some sort of special federal status. And those are all limiting principles that this court could use to narrow down the lines and determine when the treaty and when the implementing legislation apply to domestic situations and when they do not. And in this case, in Ms. Bond's case, they certainly do not, because the nature of the incident is just too far removed from Congress's intent in passing this legislation, and it would be overreaching and potentially breaching principles of federalism that are so important to our Constitution and which this court has upheld in the recent history of this court's decision-making, that principles of federalism are so important that they should not be allowed to encroach upon traditional areas of state regulation unless there is some sort of valid federal interest.
So what exactly does that mean for Missouri v. Holland?
For Missouri v. Holland, it means that it should be read to require some sort of balancing of national and state interests. And to that extent, it should be read to that treaty implementing legislation that can be faithfully implemented consistently with the principles of federalism should absolutely be allowed. But to a certain extent, Congress's ability to legislate under the necessary and proper clause, pursuant to the treaty power at least, should somehow be restricted to cases where there is some sort of federal interest.
Doesn't your federalism concerns come back to the mailbox, though, because had it not been a application of chemicals to the mailbox, but a theft of a letter, you would not question the federal jurisdiction if that charge was brought. And
Absolutely correct, Justice Conrad.
So
However,
it does seem that the facts are stubborn things, and in this case, you have the mailbox, the internet order. You do seem to have activity that either the activity or the facility itself, the mailbox, triggers federalism or federal concerns.
that is potentially true, Your Honor. However, the chemical itself or the method of acquiring it are not necessarily dispositive of whether or not the federal government should be allowed to prosecute. We can look at normal state criminal law. We can see that if an individual orders a gun from the internet and happens to kill somebody in the state of North Carolina, they're still prosecuted by state authorities within the state of North Carolina. A lot of criminal law is left to the states, and this case should be no different. To the extent that Ms. Bond can be prosecuted by under existing state law without violating the principles of federalism, it is preferable to construe the statute narrowly to allow for that application of state law in a case of local criminal conduct. The issue before the court really is whether Ms. Bond's local run-of-the-mill criminal conduct warrants federal prosecution at the expense of a tradition of state enforcement in this area, even when the conduct that has occurred is not of the type envisioned by Congress when passing this legislation in the first place. And for that reason, this court should reverse the holding of the lower court and reverse Ms. Bond's conviction, and in doing so preserve the balance of power between the federal and the state governments.
Right, thank you, Ms. Shaw. And for the respondent, Ms. Wade?
Mr. Chief Justice, and may it please the court, my name is Kathleen Wade, counsel for the respondent, the United States of America. This case is about the ability of the United States government to protect us all from the threat of chemical weapons proliferation, a national security issue of the highest concern in the global fight against terrorism. We ask that this court uphold the lower court's decision affirming the petitioner's conviction under the Chemical Weapons Implementation Act, and we do so for three main reasons. First, because the Chemical Weapons Convention itself is a valid treaty. Second, because the Chemical Weapons Act is valid treaty implementing legislation under the treaty power and the necessary and proper clause. And third, because both the act and the treaty itself were designed to prevent precisely the type of highly dangerous chemical attacks that the petitioner committed in this case. The Chemical Weapons Convention was created as part of a greater international effort at disarmament. The purpose of the convention was to ensure the complete and effective prohibition of the development, production, acquisition, stockpiling, retention, transfer, and use of chemical weapons. And under the convention, all signatory states were required to prohibit and penalize any individual within their territory from developing, using, acquiring, etc., chemical weapons.
How can you read the treaty and the intent to really apply to this domestic dispute? There's clearly an international disarmament intent.
Yes, Your Honor, but in looking at the issue of international disarmament, we must face the reality that in this world of modern terrorism and chemical weapon attacks, these are often issues that must be addressed at the local level. And so in skewing the scope to look at domestic issues, what appears to be an international disarmament treaty must be addressed by each nation locally on the individual level. Because what nations must deal with are non-state actors using these chemical weapons in attacks.
How is what happened here linked to any international concern?
It's linked to the general international concern of preventing chemical weapons attacks. So if we look at the facts in this case, the petitioner is a microbiologist who worked for a chemical manufacturer, and she obtained two highly toxic chemicals. One is potassium dichromate, the other is 10-chloro-10-H-phenoxarsine. And both of these chemicals, just on topical contact can cause toxic harm.
But aren't they also used in various industrial or other ordinary purposes?
Yes, Your Honor, they do have other purposes, but the nature of the chemicals is that they are relatively exotic in that the average person wouldn't have knowledge of these chemicals, and they weren't used in any ordinary industry purpose in this case. They were used with the intent to harm. And although the petitioner was intending to harm a specific person, through her choices of where to apply the chemicals, she exposed the greater public to a general risk of harm. These chemicals were applied over 2 months on 24 separate occasions to the intended victim's car door handles, her doorknob, and her mailbox. Now, each of these locations is accessible to the public, so any individual who had cause to approach the victim's door or brush up against her car, or any postal service worker that had cause to handle the victim's mailbox, were exposed to the threat of this chemical weapon.
What do you do with the argument made by the petitioner that Congress can, through the necessary and proper clause, do what it cannot do without a treaty?
Your Honor, that is a true statement of fact, but the necessary and proper clause limits treaty implementing legislation to what is rationally related to a valid treaty.
So if the United States entered into a treaty with other nations to prohibit the sale of large soft drink cans, and Congress came and implemented that treaty through the necessary and proper clause, you would have no trouble with that?
No, No, Your Honor, there might be problems potentially. The necessary and proper clause is not the only limitation on the treaty power and the power of treaty implementing legislation. There are other external limits, including whether the treaty has an international issue at its heart, whether it effectively meets the subject matter limitation that this court addressed in Missouri versus Holland when it looked at the Migratory Bird Treaty and Act and addressed whether those truly were matters for international policy that should be addressed through the treaty power. Another way that treaties and treaty implementing legislation can be implemented is through constitutional restraints in the Bill of Rights. So looking at free speech, freedom of association, criminal due process rights. And this court found that those limit the treaty-making power in the decision in Reed versus Covert, where it looked at the application of the Uniform Code of Military Justice and found that the defendant's rights in that case were violated. And finally, this court also established in Missouri versus Holland a way to analyze the national and state interests that are affected by the implementation of treaty legislation. So back to the migratory bird issue, this court looked at whether a state acting alone could effectively solve the problem and looked at the nature of the state interest and the nature of the federal interest in that case. And the court found that because a state could not effectively protect migratory bird populations, it was the role of the federal government to step in and fulfill that role.
So how do you read that? How do you read that line in Missouri v. Holland that I asked your worthy opponent about? What does the invisible radiation language mean?
Your Honor, the invisible radiation language refers directly to that balancing of state interests and whether a state could fulfill this role, solve this problem acting alone, or whether the federal government is required. Now, in this case, if we look at whether a state alone can solve the problem of proliferation of chemical weapons, just based on the facts of this case, it's clear that the expertise, the resources, the ability to orchestrate across state lines of the federal government are required to effectively address the problem of chemical weapons. Looking at just the facts in this case, the local police, when the issue was brought to their attention, believed that the substance was cocaine, and the advice that they gave to the victim in this case was to wash the surface.
Why couldn't a state investigator work in tandem with a task force or in some other way with federal authorities, make a case and bring it to a state prosecutor, ask for an assault warrant? Why wouldn't that have been an adequate reaction to this crime?
That is a possible response to this issue, Your Honor, and there's nothing to prevent the exercise of concurrent jurisdiction, but it's the fact that the state authorities weren't equipped to handle chemical weapons threats. They weren't able to understand the threat and properly deal with the threat, looking just at this case. So the advice that they gave to the victim to wash the car door not only exposed the victim to greater harm, but through the potential transfer of that substance to other surfaces that advice would expose the victim and the greater public to, the local authorities brushed the issue off and gave an inappropriate response to the actual threat.
So you have questions concerning the investigative acumen of the local investigators, but in terms of a prosecution, what is solved by bringing this case in federal court that could not have been done in state court?
There's a possible effect of deterrence, Your Honor, by looking at the Chemical Weapons Act being applied to this case. It serves to show that chemical weapons attacks will not be tolerated.
But hasn't our court, in examining the contours of federalism, haven't we of late pointed out the need to protect individuals from the arbitrary exercise of executive power? And isn't the prosecution here exactly such an example of excessive
No,
power?
Your Honor, I don't believe it is. Now, in any case of cases being brought under treaty implementing legislation, there is always a reliance on the efforts of prosecutorial discretion in choosing which cases to bring. But the conviction in this case was a fair exercise of prosecutorial discretion. If we look to the example that Justice Alito brought up in prior cases about the goldfish being poisoned by the vinegar in the bowl and that sort of crime being brought under the Chemical Weapons Act, that would be an improper use of the Chemical Weapons Act. But that's not what we have in this case. There was a great public harm.
In this case, we have a love triangle and a matter of jealousy and an intent to do harm and a violation of neighborhood tranquility. Isn't that the quintessential local and state prosecution?
Your Honor, this is more than just a lover's spat. Because the public was exposed to harm through the petitioner's actions, that brings in a national interest to protect the public against chemical weapons harm. Now,
But that interest is no different than if she used a knife or aimed a gun, or the intent is to do away with a rival, and it's as deadly with the use of a rock, a knife, a gun, as it might have been in this case with a chemical.
with all due respect, Your Honor, the petitioner's actions were more deadly than the use of a knife or a gun or a rock, because the chemical could be transferred between surfaces and was not readily apparent as a gun, a knife, or a rock could be. It's the insidious nature of chemical weapons and their exotic nature that not everyone is accustomed to recognize the threat.
Poison or antifreeze or any other manner of attempting to kill?
Your Honor, the use of poison or antifreeze could be directed solely at one individual by causing them to ingest the poison. But the use of the chemical weapons in this case were addressed not only at the intended victim, but accessible to the public. And it's looking at the greater potential harm in this case that draws the federal interest into view. At the time the petitioner was apprehended, she still had stores of both of these chemicals located in her home, and her employer, the chemical manufacturer, was missing an additional 4 pounds of potassium dichromate that had gone unaccounted from the storeroom to which the petitioner had access. And just because a male employee or another member of the public wasn't harmed in this case, we can't be limited by the fortuitous results. Instead, we must look to the potential harm that the petitioner's actions expose.
So are you saying the limit to what Congress can do under the Necessary and Proper Clause is the enumerated constitutional limitations, or is it beyond? Is there something beyond that? What are the limits?
There are 4 distinct limits. One is the Necessary and Proper Clause itself, which requires the rational relation. Another is the subject matter limitation, addressing the treaty itself. Another are the regular Bill of Rights constitutional restraints. And finally, to address the 10th Amendment specifically, this court in Missouri v. Holland brought forth the interest balancing test, looking at the national interest. So those are all external limits that can be applied to limit the treaty powers.
So it sounds like what you're saying is that the treaty itself and the enumerated powers of the constitutions are the limits to Congress, so it can do anything beyond that.
Yes, Your Honor, it can do anything within those limits.
Within those limits.
It's also important to remember the internal limits of the treaty-making process and the implementing legislation process itself. That requires the consent of a foreign nation, a 2/3 vote in Congress, and then the passing of the act itself, presidential approval, and then the prosecutorial discretion to actually bring forth convictions under this act. So Congress's acts are not unlimited. They don't somehow use the treaty power to gain a blanket immunity from any constitutional challenge, and they're not able to use the treaty power to make a blank check to address any sort of legislation that they choose to. There are limitations.
If a treaty entered into by the United States allowed for the surveillance of purely domestic telephone calls, would Congress be allowed to, through the Necessary and Proper Clause, put that into effect?
Your Honor, that would bump up against Fourth Amendment limitations on searches and seizures. So those constitutional restraints in the Bill of Rights do apply to treaty implementing legislation in the United States. Once the United States tries to execute that treaty under congressional legislation, a constitutional challenge can be brought, and that can be prevented. Now, if we look at the act itself, the terms of the act directly prohibit the petitioner's action in this case. All nations were required to prohibit any use, possession, production, acquisition, and Congress carried that out by creating the Chemical Weapons Act. Now, under the Necessary and Proper Clause, the legislation must bear a rational relationship to the treaty in question, and in this case, the act mirrors the language of the treaty. Aside from some slight word changes, there's no material expansion from what was required of a signatory nation and what Congress required in the legislation. And in these cases, Congress is due some deference due to their position to make findings of fact, to make important policy determinations, especially in situations that involve concerns of national security. Under Missouri v. Holland, this court has held that if a treaty is valid, then the implementing legislation of that treaty is valid.
So you're suggesting Missouri v. Holland should be reaffirmed. It's as solid as it was in 1920 today yet?
Absolutely, Your Honor. Missouri
no tinkering at all?
No tinkering is necessary, Your Honor. Missouri versus Holland fully laid out the validity of a treaty and its implementing legislation while still addressing subject matter limitations and the nature of the national interest at hand. Missouri versus Holland, the decision was flexible enough entirely to address the situation that we have at hand. And in fact, this court holding that the treaty implementing legislation to address migratory birds in Missouri versus Holland, if they found a national interest there, then surely where we're dealing with matters of national security, looking at the proliferation of chemical weapons, a national interest can exist in those cases. May I conclude?
Well, let me
You
ask
can
one
conclude
more
that.
question. In your opinion, why is the Fourth Amendment a more effective limitation on the necessary and proper clause than the 10th Amendment?
Both are effective limitations, Your Honor. It's just that the way that the necessary and proper clause interacts with the 10th Amendment, as established in this court in Missouri versus Holland, is through that balancing of state interests. So the 10th Amendment is a limitation, but this case meets that limitation.
You can conclude your last thought.
Under the language of Holland, limiting the proliferation of chemical weapons is a national interest of nearly the first magnitude. The Chemical Weapons Act addresses precisely the type of conduct that the petitioner engaged in this case. A state acting alone cannot prevent the possession and use of chemical weapons effectively. Because the petitioner's repeated use of dangerous chemicals in areas accessible to the public is within what Congress intended to prevent through passing the Chemical Weapons Act, we ask that this court uphold the lower court's decision to affirm the petitioner's conviction.
All right, thank you, Ms. Wade. Your rebuttal. Shaw.
Mr. Chief Justice, and may it please the court, respondent contends that petitioner's conduct falls within the scope of an international treaty on chemical weapons. It is unlikely that the leaders of several nations envisioned Ms. Bond's conduct when writing this treaty. In the past, this court has declared unconstitutional federal legislation regarding criminal activities when they encroach upon state powers. Section 229 is so broad, it allows for federal prosecution in cases traditionally governed by state law. There must be a limit to what Congress can do under the necessary and proper clause when enacting treaty implementing legislation. However, this court need not determine that limit today. Ms. Bond's challenge to the Chemical Weapons Convention Implementation Act is as applied to her case alone and not to any hypotheticals posed by the respondent. Ms. Bond did not travel across state lines or harm a significant number of people. It took her...
The one chemical did, though, didn't it? The one she ordered off the internet that came across state lines.
Yes, Your Honor. The chemical did travel from across state lines. However, it took Ms. Bond 24 attempts, and the worst injury that resulted... Your Honor, I see that my time...
You can conclude that thought.
Thank you. It took Ms. Bond 24 attempts, and the worst injury that resulted was a minor burn. The chemical was available in a storage cabinet in an open area at work, and despite the safeguards cited by this respondent, this is not the activity that is contemplated by the Chemical Weapons Convention, and it should not be the kind of activity that justifies federal prosecution under the implementing legislation today. Therefore, this court should reverse the lower court's decision and hold that the Chemical Weapons Convention Implementation Act is unconstitutional as applied to Ms. Bond's case. Thank you.
All right, thank you to both counsel. We'll take this very interesting matter under advisement and be in recess.
All rise.
Thank you all. If we could have a quick round of applause for our finalists. And sorry, please be seated. The judges will return in a few minutes with their verdict. Sort of head back to your seats. The judges are on their way down.
All rise.
Please be seated. Well, good afternoon again. We were presented with a very close case, very interesting fact pattern, and the combination of the treaty and the statute and all were really interesting challenges to us because it's not something that comes to us on a day-to-day fare, but in terms of the lawyering that was done, we were really just remarkably impressed that in such a short period of time, 2 days, you were able to absorb these really difficult areas, difficult cases, and the language, and work so well. And the way we thought your presentations were much like the best of what we see in our day-to-day work. And so we're very confident you're going to do very well, not only in law school, but when you're with your practices ahead. And after much weeping and gnashing of teeth in our conference room, we ended up giving the slight edge to Ms. Wade. Ms. Wade, congratulations. But as I said, very close call. Ms. Shaw, you did a wonderful job. And one of the things that we thought that Ms. Wade maybe got a little edge on is in terms of listening to the questions that we asked. We felt that maybe she was able to be a little more responsive to the particular questions we asked, and that we felt was very helpful to us, and it was showed the ability to sort of break down these concepts into a conversational way, so that there's a little more back and forth with us, which is very helpful to us. But we thought you both showed really good knowledge of the record and the language of the statute and the treaty itself, and thought the presentations were really quite good.
I would defer to my...
I was amazed, as I understand it, you had 48 hours to get this together, and to be 1Ls and have this complicated a subject matter to figure it out, to think about it, and then to deliver it in such a persuasive way. We were all really impressed with that effort. And I thought particularly, Shaw, you had great themes. You argued, the advocacy instructors would say primacy and recency are very important to persuasion, and you had your theme and you stuck to it, and you delivered it, and then you ended with it, and I thought that was very good. I was curious that you only reserved 1 minute for rebuttal, and my thought was that's the time when you have the judges for yourself, and there's nothing that you say that can be countered by your opponent, and so I was wondering whether having a longer period of rebuttal might have been better. And then, Ms. Wade, you were fantastic. I thought the points that you made were really good, and one of the most persuasive things you said in terms of my understanding of the case, when you talked about the general risk to the public, and you broadened the act of violence beyond the rival to, the way she did it affected others, and I thought that was a very persuasive point, and I thought you were extremely conversational in a way that added to your persuasiveness. So we were very impressed with both of you. This would have been good if you had had months to prepare, but the short time that you had the case and what you did with it was outstanding work.
I have very little to add except to agree that in terms of demeanor, presence of mind, response to the questions, you really both did excellent jobs. To the extent I hear any appellate arguments, it's usually in the bankruptcy context, but I would welcome either of you in my courtroom, and you would instantly have very good reputations. I do think mastery of the record, that the respondent here was able to use that really effectively in what I think was a very difficult case. While I agree with the oral advocacy position, I might be persuaded ultimately by the petitioner's briefs. I think it's a really tough case, but you had anticipated, I think, every tough question, and both of you had really wrestled, I think, with Missouri v. Holland, important precedent, and thought about how that worked in each case, for you. I just wanted to point out that to the extent you want to go on to litigation, and to all of you in the audience here, many courts now have pro bono panels. When Dean Levy was the chief judge of our court, he helped start our pro bono panel. And I think when he left, we had maybe 13 people on that panel. We now have 200. And it's a chance for young attorneys. If you end up in a big firm and you're doing discovery and working on motions, but you want a chance to get into court, see if your local courts or your local bars have panels like that, because it can be a way, if a firm will give permission, for you to get into court and build on your practice as an advocacy in a way that really assists the courts.
Had you argued the opposite sides on the way up through the earlier rounds? So, are you on the side you would have liked to have been on, or would you rather been the respondent?
Both happy with
Great, 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 great. I'll just say two other things. One is the physical dynamics here are so different than every other courtroom I've ever been in. Never do the lawyers look down on the judges, and that was a little intimidating for us. You think we're smarter when we're up above you looking down at you.
We think we're smart.
But as you prepare arguments going forward in practice, keep in mind, in almost every federal arena you're going to be in, the judge is a generalist and not an expert in the area that you're in, and you are probably expert in the area. So as you're preparing, vet your briefs and your arguments to people who are not experts in those areas. If you've got, say, an ERISA issue, don't just talk to the ERISA lawyers about it. Talk to lawyers who do real estate or criminal law or something, so that you see what their questions are, what their concerns are, or how can you present it so someone who is not expert in that area can understand it. That's always very helpful, and I thought you both did a nice job dealing with some kind of special areas that aren't familiar to us on a day-to-day basis. So think about vetting your cases to those who are not experts. I think you'll find that's a good way to prepare for a generalist court. Any particular questions from audience members, the lawyers themselves?
Y'all just want to be done with it.
Yeah, right. You got finals coming up, so thank you very much.
If you would all just join me briefly in a thanks to our panel. Thank you all very much. They dedicated not only their time tonight, but it was clear from their questions, time preparing and getting familiar with this problem. So for that, I'm very grateful. Congratulations again to our finalists. That concludes the 2013 Hardt Cup, and I invite you all to join us for some light refreshments on the third floor mezzanine of Star Commons. So thank you all very much.